First, thank all of y'all for being here. I know this is hard on both sides of this. There's no winner, no loser. Well, there's two losers and two losing families here today, and so I appreciate y'all being here. This is a tough one for me. I typically have a whole bunch of notes written on the front of my PSIs on what I'm thinking about doing. I don't have that in this one. I've thought about it a lot. I've sat through some trial or two with regard to fentanyl, and there's some things that I agree with both Mr. Coleman and Mr. Radford on with regard to the specific law itself. I think who it was intended for with regard to fentanyl, but that's not.
Apologize for interrupting the court, Judge, but you understand that we refiled.
Yeah. I know.
We're not
I'm just.
proceeding on that.
And that's what I was getting to that. I think everybody's kind of realized what the intention of that um, statute is and was, and I understand why the state has changed this, and it makes sense. I understand the family wanting you to go away for a long time. I get that. I feel like I probably would too. I also get, I believe, with the best that I can, I believe that you did not know there was fentanyl in that. I think that is been fairly clear in this case that there wasn't an intent to distribute fentanyl. The problem comes in that you're distributing drugs in the jail, you know, and that fentanyl is such an issue. It is a little hard to believe that you wouldn't have an idea that it could have it in there. Every drug nowadays could have it in there, every single one. And we're seeing more and more of those in here. And so for people that are distributing or addicts that are using, it is hard to really believe that you don't have some idea that it could. I also know that people who are in the middle of addiction aren't thinking about anything other than getting high, and you're thinking you're getting high on heroin. And I'm going on and on a little bit because I honestly don't know what I'm going to do. There is a side of me that has no doubt that you probably deserve to go away for a very long time. I don't think you intended to kill anybody at all. I think there are other cases in this court where people have much more malicious intent. And then, can you come back later? That's okay. So I just think there's cases where there's much more malicious intent, where people are given certain opportunities here for different types of offenses where they really do mean to do harm to someone, and they're given opportunities. The criminal history concerns me because it's drugs. You've already been to Safe P. You've been given those tools, and you're saying all the right words up here today about what you want to do, and you want to go to AA, and you want to volunteer and go to the church. And the time for that was back in 2015 too, when you went to Safe P the first time. Here's what I'm thinking about, and I really hadn't thought about it before, and is what Mr. Radford actually brought up, and I've done things like this in other cases where someone is given, because they have two cases, I kind of have two options to do two different things, which give the impact of going to prison for some amount of time, and then Ms. Cormier, if you really want to change your life, you might have that opportunity. And if you don't take advantage of that opportunity, I can assure you that I won't forget these faces that are staring me right now, probably going to disagree with what I do. Okay. So I will have the rest of your life to do what I need to do if you are not serious about what you're talking about doing. So what I'm going to do in cause number 25 DCCR 1447, find that you entered your plea freely and voluntarily, and at this time find you guilty of possession of a controlled substance. I'm going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 1448, I'm going to find sufficient evidence to find you guilty. However, in that case, what I'm going to do is defer all proceedings and place you on probation for 10 years. And let me explain what that means. The deferred probation is not for you. That's for me. And that's for the family, even though I know they may not feel like that today, but that's for them. That means when you get out of prison, you do the 5 years in prison, you get out, you're going to be on probation for 10 years. And if you violate your probation in any way, you will be on zero tolerance. You will, if you need help, you're going to have to ask for it. I'm not going to sit here and order a bunch of stuff that you may or may not need in 5 years. You test positive one time, zero tolerance means you don't get to come in and go, now I need safe P. Now I need help. Now I'm going to go to AA. Now I'm going to do these things. That opportunity is gone. You either figure it out or you're going to prison for probably as long as they're asking for or longer. All right. Any conditions other than the zero tolerance, I'm really not inclined to be specific. Mr. Coleman, whatever they assess and determine she needs when she's released from prison is what I'm thinking would be appropriate, but I would definitely listen to anything you had to add.
Nothing comes to mind, Judge. I'll defer to the court and the probation department.
So what they'll do when you're released from custody is do an assessment. And if they think you need to go to safety at that point, whatever it is, I don't care what it is. If they think you need to go to safety, you go to safety. You don't say, oh, let me call Mr. Radford and I've been in prison for 5 years and I don't think I need to go now. I don't want to hear anything about it. If they say you go, you go. If they, whatever it is, if you violate, then you'll be back in here immediately with any violation. I just don't know how to make that more clear.
I understand.
So you'll be handed in a minute the trial court certifications in each of these cases. These were not agreements, so you do have some rights to appeal. And I'm trying to think, I had something else that I thought I was going to make a condition.
Does it my understanding that she will be on probation, the probation time will start when she's released from TDC?
I think it actually starts now.
Okay.
Yeah, I don't think I can postpone that because it's an invariable date. We don't know for sure when that's going to be. So technically it starts now. So it'll depend on parole, when and if she makes parole on that first case. Then you're already on probation, immediately report. And so at a minimum, there will be 5 years after that I will have supervision. Maximum, if she makes parole, it could be even more or longer than that you'll be on supervision. But no, it'll start now.
I'll explain that to her.
Yeah. I wish it could be the other way. I wish it could start later and that would give me more supervision time. But for everybody that know or is here, 10 years is the maximum probation. So if I could do longer, I would. But if someone's really going to get their life together, we're going to know probably within 1 year. I would think if you're really serious about this, then 5 years is long enough for us to get that figured out, hopefully. I know there's going to be a victim impact statement. Mr. Coleman will go off the record and they can come up and we'll have one victim impact statement.
Could I have a moment to explain to her what that is?